Welcome to the third episode on the data breaches. Discussion with my special guest, Thanuki. Today, we're going to be talking about third-party data exposure. In our previous episode, Thanuki briefly mentioned about the third-party vendors and the supply chain related attacks. So in this episode, Thanuki would provide insight in terms of where would we say there is a database linked to a third-party service provider, it could be a third-party vendor, or a supply chain attack. Thanuki, take it all. It's yours.
Right. Okay. So here we're going to be looking at the legal implications of data breaches involving vendors or third parties or partners,
That's
focusing
right.
on contractual protections and certain due diligence requirements. And I'm also going to try and weave in how the Sri Lankan law, the Personal Data Protection Act, also kind of fits into this landscape. I'm going to
Sure.
try because there's some time for this to become fully operational, but we can still look at some
Absolutely.
provisions. So when a breach occurs through a vendor or a partner, the primary organization who, when we talk about this in data terms, we call it the data controller, often faces a lot of legal heat. So even if the vendor's failure is what sparked that incident or caused that incident, the implications span regulatory penalties, it can be lawsuits, it can be reputational damage, with vendors sometimes sharing this responsibility or liability, depending on the jurisdiction and also the contractual terms as well. But I think at the base of this, what we need to understand, even in a legal sense, would be that you should not at any point be trying to pass the ball on to the other party. Accountability has to be seen as something that you um, consider of paramount importance to an organization that handles data of individuals, no matter what it is. That should be at like the baseline at all times. So if we talk about legal implications, if we talk about go right into regulatory liability from a global context. So we know that you have the GDPR, which is the General Data Protection Regulation of the EU. Here, controllers must ensure that vendors, so the vendors are essentially what we call processors, how they implement adequate security. A vendor breach doesn't excuse the controller. There can be fines up to, I think, about 20 million euros or so uh, for both parties. It can hit both parties. So an example of this is in 2019, British Airways breach was there, which was a third party. It was a third party vendor situation. It led to a 20 million euro fine, despite the vendor's role. So you need to remember that you may outsource this onto someone, but legally you will have to bear some form of responsibility, uh,
Absolutely.
in this instance. Again, if you look at the US, if you take California, you have their Privacy Act, where businesses must notify residents of breaches involving unencrypted personal data, and there are statutory damages that can be awarded between 100 to $750 per person, possibly if security lapses, including vendor oversight, are proven. So that's how the vendors get tied into that conversation in the US, especially if you take this CCPA in California. It's a pretty big regulation there.
Mm.
And also you have HIPAA, which is in the US, it is for health-based information portability based act, that is. And there also it covers entities covered entities pay for vendor breaches, like there was a advocate healthcare settlement in 2016 after a vendor exposed 4 million patients' data. So I think that was like a over $5 million dollar settlement that was because of that. So again, you can see regulated liability. It can go both ways. It can be the controller who ends up paying a massive fine, or it may be the vendor who does, or it can be a shared responsibility situation. Then if you take civil liability, you have affected individuals can sue for negligence or breach of implied duty. So in 2013, the Target breach, which we spoke about a little bit in the previous episode, by an HVAC vendor, cost target 28.5 million in settlements despite the vendor's initial failure. Courts focused on target's oversight responsibility at that point. Okay. And if you look at Sri Lanka a bit, in Sri Lanka, it applies to data processors and controllers targeting Sri Lankan residents. So, under Section 7, controllers must ensure that the processors or vendors comply with security obligations. And a vendor breach exposing personal data like names, IDs, financial details, etc., can trigger mandatory notification to the Data Protection Authority and the affected individuals, right? And there are penalties for non-compliance up to 10 million Sri Lankan rupees. But that will be assessed by the Data Protection Authority based on impact and negligence. Something that we need to focus on in Sri Lanka is that these are very administrative in nature. It's not so much in the same way or strength as it is in places like in Europe or even in the US. How fines are used, it's very different. I would think in Sri Lanka, or what is envisioned for it to be in Sri Lanka is very different, right?
Okay.
Um, so that's something to keep in mind. And then this idea of joint liability. Globally and in Sri Lanka, regulators may penalize both parties. So the PDPA allows the Data Protection Authority to issue directives to non-compliant vendors with fines following non-adherence. So we are yet to see how that comes into play in the coming months.
Right.
Then I would also add on to that a bit on maybe some things like contractual protections, because when it comes to regulatory liability and things like that, even contracts play a big role when it comes to this. It's critical to managing vendor breach risks. And it's important that you have a strong legal team to support you when it comes to contracts with vendors, especially when it comes to any technology that deals with data. And in those ways, it's important to pay attention to indemnification clauses. What are your security obligations? What are the breach notification terms? What are the termination rights? And what is the limitation of liability, if any? These are some of those key factors that need to be addressed when it comes to your contracts, especially your security obligations and indemnification aspects have to be focused on significantly, I would think.
I have a question. You spoke about on penalties and fines in the US, Europe, or even Sri Lanka. Would any of these laws actually require anybody to be penalized and also serve jail term?
Well, okay. So in I would think like in Sri Lanka we have um, two laws at the moment where you can
Okay.
the idea of jail term. Um, well, in yes, I will. Yeah, just we'll stick to the Sri
Let's
Lankan.
do this. Let's do this.
Yeah,
And if there are any references, we'll
yeah,
post the links at the bottom of the video, right?
yeah,
Because that's something I think would be of interest to people to know as part of their responsibilities,
yeah,
right? So I mean that's something which is going to be of interest, and so hence how things could evolve in the future.
yeah.
So Thanuki,
Sure.
thank you so much, and thank you so much for sharing your insights on how the third parties would be impacted if in the event of a data breach, knowingly or unknowingly for their acts. So when we come back, we would be talking about the unsolicited use of breached data. So that's going to be an interesting conversation as well. So viewers, please stay tuned to our next episode. And if you've not watched our previous episodes, please make time to listen to them. And they are very short ones. It doesn't take much time for you. It's some are less than 10 minutes, some are less than 15 minutes. So I'm sure you would gain a lot of value listening and watching into these videos. Thank you so much, Thanuki, and I'll see you on the other side for the next episode.